and another part of the series of fundamental rights and fundamental duties in the series of our constitution. The expression prerogative right is one of English common law which refers to the extraordinary writs granted by the sovereign, a fountain of justice on the ground of inadequacy of ordinary legal remedies. In course of time, these writs came to be issued by the High Court of Justice as the agency through which the sovereign exercised his judicial powers, and these prerogative writs were issued as extraordinary remedies in cases where there was either no remedy available under the ordinary law or the remedy available was inadequate. These writs are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. In the sense, the power of high courts to issue these writs is wider than that of the Supreme Court, inasmuch as under 32 of the Constitution, the Supreme Court has the power to issue these writs only for the purpose of enforcement of fundamental rights, whereas under Article 26, a High Court can issue these writs not only for the purpose of enforcement of fundamental rights but also for the redress of any other injury or illegality owing to contravention of the ordinary law, provided certain conditions as satisfied, for which see Chapter 20 Post 161. Thus, an application to the High Court under Article 226 will lie not only for the fundamental right has been infringed, but also where some other limitation imposed by the Constitution outside Part 3 has been violated, as for example, where the state legislature has imposed a sales tax in contravention of the limitations imposed by the Article 286, but an application under Article 32 shall not lie in any case unless the right infringed is fundamental right enumerated in Part 3 of the Constitution. Another point of distinction between the two jurisdictions is that while the Supreme Court can issue a writ against any person or government within the territory of India, a High Court can under Article 226 issue a writ against any person, government or other authority only if such person, government or authority is physically resident or located within the territorial jurisdiction of the High Court, that is within the state or which the territorial jurisdiction of the particular High Court extends, or if the cause of action arises within such jurisdiction. As stated earlier, the Supreme Court has been assigned by the Constitution a special role as the protector and guarantor of the fundamental rights. Where therefore the infringement of the fundamental rights has been established, the Supreme Court cannot refuse relief under Article 32 on the ground that the aggrieved person may have his remedy from some other court or under the ordinary law. That disputed facts have to be investigated or evidence has to be taken before relief may be taken to the petitioner, that the petitioner has not asked for the proper writ applicable to his case. In such a case, the Supreme Court must grant him the proper writ and, if necessary, modify it to suit the exigencies of the case. Generally, only the person affected may move the court, but the Supreme Court has held that in social or public interest actions, any person may move the court. This is called expansion of the rights to be heard. It favors public interest litigation. Following English and American decisions, the Supreme Court has admitted exceptions from the strict rules relating to affidavit locus standi and the like of the case of a class of litigation classified as public interest litigation, that is, where the public in general are interested in the vindication of some rights or the enforcement of some public duty. Another consequence which results from the guarantee of the constitutional remedy under Article 32 is this: not only this remedy immune from being overridden by legislation, but any law which renders nugatory or illusory the Supreme Court's power to grant this remedy shall be void. This was illustrated in the leading case of Gopalan versus State of Madras, where the Supreme Court invalidated Section 14 of the Preventive Detention Act 1950, and it originally stood. The section was as follows: no court shall, except for the purpose of prosecution for an offense punishable under subsection 2, allow any statement to be made or any evidence to be given before it, or the substance of any communication made under section 7 of the grounds on which the detention order has been made against any person, or of any representation made by him against such order. And notwithstanding anything contained in any other law, no court shall be entitled to require any public officer to produce before it or to disclose the substance of any such communication or representation made, or the proceedings of an advisory board, or that part of the report of an advisory board which is confidential. It shall be an offense punishable with imprisonment for a term which may extend to 1 year, or with fine, or with both, for any person to disclose or publish without the previous authorization of the central government or the state government, as the case may be, any contents or matter purporting to be contents of any such communication or representation as referred to in subsection 1. The Supreme Court struck down the above provision on the ground that it contravenes Article 32 by way of preventing the Supreme Court from effectively exercising powers under Article 32. This is all about today's part of fundamental rights and fundamental duties. Thanks, regards.